What are company employee record retention policies? Imagine trying to find a crucial document during a legal review or an employee dispute. That's why having clear rules about how long to keep employee records is so important. These policies are formal guidelines that tell employers exactly what records to keep, how long to keep them, and how to store and dispose of them properly. They help ensure the company follows the law, protects employee rights, and avoids legal trouble. Most policies cover different types of records. For example, pre-employment documents like applications, resumes, background checks, and reference checks should be kept. When someone gets hired, their offer letters, employment contracts, performance reviews, disciplinary records, and termination papers are also important to retain. Payroll and tax records are another key area, including wage payments, tax withholdings, and benefits information. Time and attendance records are especially vital for hourly and non-exempt workers. There are also compliance-related documents to consider. These include forms like the I-9, which verifies employment eligibility, records related to the Family Medical Leave Act, OSHA logs for workplace safety, and health insurance records. If there are discrimination complaints or lawsuits, related records need to be kept until the case is resolved. Retention periods vary depending on the type of record and local or federal laws. For example, employers should keep I-9 forms for at least 3 years after hiring or 1 year after employment ends, whichever is longer. Payroll records should be kept for at least 3 years, and OSHA logs for 5 years after the year they cover. Health insurance records are kept for 6 years from their creation or last update. Discrimination records are kept until any legal case is finished. Time records for hourly workers are often kept for 3 or 4 years, but some states requiring longer. Pay stubs are usually kept for at least 3 years. Storing records securely is a must. Paper records should be kept in locked cabinets with limited access. Electronic records need encryption, strong passwords, and secure servers. Regular checks help make sure data stays protected. When records reach the end of their required retention period, they must be disposed of carefully. Shredding paper documents and securely deleting electronic files prevents unauthorized access. Having a written record retention policy helps employers stay organized and compliant. Human resources staff or designated personnel should manage the schedule and ensure outdated records are destroyed on time. Regular audits of record-keeping practices help avoid mistakes and prepare for inspections or legal claims. Sometimes, keeping records longer than the minimum required can be helpful if it helps defend the company in disputes. From a workplace rights perspective, proper record retention protects employee rights by maintaining accurate employment histories, wage records, and safety documentation. It also helps employers avoid penalties for not following record-keeping laws. Clear policies balance legal needs with employee privacy and data security. Following these rules ensures everyone's rights are respected and the company stays on the right side of the law.